Today we have with us Mr. Paul REICHLER. He's currently Associate Member of 11 King's Bench Walk Chambers, London. Mr. REICHLER is a renowned practitioner of public international law since 1981, representing states in disputes against other states before the ICJ, the ITLOS, the International Arbitral Tribunals, and representation of states in arbitration against foreign investors. The topic of his lecture today is international litigation. Mr. REICHLER, please.
Good morning, everyone. First of all, can you all hear me? Way in the back, in the corner? All right, fine. If at any time you have difficulty hearing me, just raise your hand and I'll know and I'll speak louder. It's a great privilege, an honor for me to be invited here to participate in the third annual Tokyo International Law Seminar. I'm particularly pleased to have been invited back because I had the honor of speaking at the first and second Tokyo International Law Seminars, and it is always a privilege to be here in Japan. I think based on my observations at the first two seminars, I think you would be right to expect a very interesting, a very informative, and a very pleasurable week here, listening to some very, very renowned speakers. And I will say it gets better after I speak. You'll see, you'll be meeting some really, really interesting and informative people, very prominent in the profession. And of course, a huge part of this is the opportunity for you to engage not only with the speakers, but with each other, and to exchange your views on topics of very, very high level of importance to the international community. I want to thank particularly my hosts, and particularly those from the Ministry of Foreign Affairs for inviting me again. I noticed that among the participants, there are quite a number of you from states that I have had the honor of representing in international litigation or arbitration in past years, and a few that I have litigated against. But I hope we can exchange views on some of those experiences, and particularly what you and I have learned about the practice of litigation through those experiences. I am a practitioner of international litigation. That's what I do. It's been my career for the last 40 plus years. What does that mean? It means that I specialize in representing sovereign states in disputes, litigation or arbitration with other states, before the International Court of Justice, before the International Tribunal for the Law of the Sea, and before arbitral tribunals around the world. And I also represent sovereign states in disputes with foreign investors before such, or under the rules of ICSID, the International Center for the Settlement of Investment Disputes, the Permanent Court of Arbitration, and the International Chamber of Commerce. And on top of that, I'm often consulted by states in a non-litigation setting or in a pre-litigation setting to provide advice on disputes that they have with other states, usually neighboring states, and whether a decision should be made to institute litigation or arbitration, or I consult with states that are concerned that if they engage in certain projects or activities, they may invite litigation against them by other states, and how best to avoid being sued or minimize the risks of being sued successfully. Now, my CV, which has been provided to you, identifies many of the cases in which I have been involved as counsel. If any of these cases is of interest to you and you would like to know more about them, or more about how they were litigated or litigation strategy, I'd be glad to answer them, either here in this forum or outside during breaks. Please feel free to approach me with any questions you have. I'd be delighted to engage in conversation with you. And I hope that you will feel comfortable enough to ask any questions that you have, or raise any points that you consider interesting or that might be interesting to the group. I hope you'll feel free to do that anytime during the presentation. Or I hope this will turn into, at least in part, a discussion among us. I think we all learn more from discussion, from participation in questions and answers and exchanging our viewpoints, than we do from sitting for an hour or more, or 2 or 3, listening to a lecture. So I'm prepared to talk if that is the circumstance, but I would also welcome the opportunity to listen to your questions and your comments, your views about international law or litigation. So I'm going to invite you to speak at any time during this presentation, this morning, both before and after lunch. And simply raise your hand, and I'll make sure that I'll call on you promptly, and we can all have the benefit of hearing what you have to say. The subject, or the subjects that I will be addressing here, are the practice of international litigation. And I will say very little about the law, and my focus will be on the practice, how we practice international litigation before international courts and arbitral tribunals. Right? For those of you who litigate or supervise litigation from your governmental positions, I hope that you will come away from this having learned of some very valuable techniques, skills, strategies that you can apply in your work. For those of you who don't litigate, I hope as well that this will be informative and useful to you to understand how litigators think and practice, and when the time comes that your state is involved in international litigation or arbitration, you will have a leg up on the process and be able to participate more effectively in directing the lawyers who work for your state. My wife is a university professor, and she always tells me that don't just lecture, that students, or anyone really, she's talking about students because she's a professor, people learn more by participating than by listening. Now, I hope by listening to me, I will be able to provide some useful information to you. But really, I want to encourage your active participation as much as possible. Now, I've been over the list of participants, and while I don't remember people's names, I have noticed that there are a number of you from countries that have been involved in litigation before the International Court of Justice or before International Tribunal for the Law of the Sea, or in interstate arbitrations, including Indonesia, Cambodia, Singapore, Djibouti, Thailand, the Philippines, Malaysia, India, Pakistan, Qatar, Saudi Arabia, Bahrain, Uganda, Nigeria, Mauritius, and Kenya, and Djibouti. So you might not have been personally involved in any of these lawsuits or arbitrations, but your state certainly has experience, and so I hope you'll be able to share your thoughts, your observations, what you've learned about managing international litigation from your involvement in those cases. One more comment on the process. You know, as a litigator myself, and this is another way of inviting you to contribute to the discussion, as a litigator myself, we don't mind being interrupted. In fact, we appreciate that. When we're arguing before a court or an international tribunal, we hope that there will be questions from the judges or the arbitrators. And one of the reasons for that is because it lets us know what the judges or arbitrators are thinking, what they consider to be important, what they want to hear from us. Our job, of course, is to persuade them of the justice of our client's case. But in order to do that, we need to know how they are seeing the case, what they think are the important issues, what questions they have, which may be very different from what we anticipate. And of course, we construct our presentations based on what we think the judges or arbitrators should hear or want to hear. But the best way of really satisfying them is if we know from them by their questions what interests them, what they think are the factors that will most influence their decisions. So again, let me know what you think, and I'll try to address the issues that concern you. Now, as I begin to talk about litigation practice, I should say that to give a really complete course on international litigation or arbitration would take at least a full semester, if not an entire academic year. So there is inherently a limitation on how much we can cover in the periods assigned to me both before and after lunch today. But I think we can cover a lot of interesting ground, and perhaps, I hope, the most interesting aspects of international litigation, and share some information that will prove valuable to you in the course of your work. So to that end, the topics that I would like to cover with you are the following. First is the decision to resort to litigation or arbitration against another state? What are the circumstances that drive states to sue one another? And I'll give some examples from my own experience representing states that did decide to initiate litigation against other states. The second aspect is the composition of the legal team. And this may be of practical use to you as a government official. How do you compose your legal team for an international litigation or arbitration? What are the different components of the team, both national and international? And particularly when you are looking for the best counsel for your case, what are the criteria that you might employ? Then third will be putting the case together. How do you build your case to be presented to the court or arbitral tribunal, including the legal and factual elements and the structure of your case, of your arguments? All of this is before the litigation or arbitration begins. So fourth is the actual commencement of the proceedings. How are the proceedings commenced? Normally by an application by the applicant state, which brings the case. But what are the elements that go into an application? And what are the circumstances in which the applicant would apply at the time of the application for provisional measures at the outset of the case? Then, after the commencement of the case, would come the preparation of the written pleadings. As many of you, if not all of you, know, in international litigation and arbitration, there are normally 2 rounds of written pleadings. The applicant files the memorial, the respondent files a counter-memorial, and then the applicant files a reply to the counter-memorial, and the respondent state files a rejoinder. That's it. And those are the 4 written pleadings, 2 rounds. Each state gets 2 written pleadings. So we'll discuss we'll discuss what goes into the written pleadings, and particularly what makes some written pleadings outstanding and what makes them mediocre or even poor. And in all my 40-plus years, I've seen hundreds of these written pleadings, and they do range from outstanding to poor. So I hope to give you some of the things that I have learned through drafting written pleadings and also reading the written pleadings of others as to how to present a better written pleading. And then at the conclusion of the written phase of the case come the oral pleadings, the oral hearings. And perhaps we'll get to that after the lunch break. But again, based on my experience litigating cases, arbitrating cases, there is a huge variance in the quality of oral pleadings that you make or listen to. And I'll try to give you my best thinking based on my experience, both making oral arguments and listening to them, as to what factors distinguish the best oral pleadings from those that leave something to be desired. Before proceeding further, I'd like to comment on a common theme in the opening presentations, both by the Honorable Foreign Minister and the Director General of the Bureau of International Legal Affairs. And that is the critical situation we find ourselves in today in regard to the strength, the vitality, and challenges to the rules-based international order. Just 5 years back, we were in a different era than we are now. The challenges to the rules-based international order seem greater at this moment in history than perhaps at any time since the end of the Second World War. There are obvious and blatant violations of some of the most important, most vital, most peremptory norms of international law coming from great powers in Asia, in Eurasia, in North America, and in the Middle East. We see blatant violations of the prohibition against aggression, against the use of force, against violations of the sovereignty and territorial integrity of other states. We see blatant and horrendous violations of peremptory norms of international humanitarian law. We grow more shocked every day when we hear the news about the destruction of human life in Gaza. And more despondent over the seeming failure of the international community to do more than issue relatively weak criticisms without the kind of actions that would be required to save human life or hold accountable states that commit the most egregious violations of the United Nations Charter and the Fourth Geneva Convention. It is a time, we live in a time when many people, people like you, government officials, people like me who've dedicated their careers, their entire careers, and really most of my life to working for the rule of law in international relations. And many of my colleagues are asking themselves, what do we do now? Was everything that we did wasteful? Where do we go now? I think this is a time that we have to respond not by despondency, not by depression, but by a renewed commitment to what we believe in and what we know is essential for peace, security, order, and justice in the world. we have to work harder. We have to renew and redouble our commitment to the rule of law. When I entered the building today, perhaps you saw the same thing I did. There were posters that advertised on the second floor of this building an exhibition of posters of the attacks on Hiroshima and Nagasaki. This week, in fact, the day after tomorrow, the 6th of August, will be the 80th anniversary of the bombing of Hiroshima. And of course, Saturday will be the 80th anniversary of the bombing of Nagasaki. Years ago, during my first trip to Japan, I had the occasion to visit Hiroshima and the museum there. I don't know if any of you have had a chance to visit it. While you are in Japan, I would strongly recommend, if you have the opportunity, that you visit Hiroshima and spend time in the museum there. It will change your life. It will certainly change your outlook on life. And as international lawyers, I am sure it will let you know why you have chosen to specialize in international law and how important it is. There is a corner in the museum that is dedicated to the rule of law as the best hope of mankind to assure that nothing like Hiroshima or Nagasaki ever happen again. And it is no wonder that of all the states I have been honored to represent in 40-plus years of international practice, and there are quite a number of them, there is no state that I have ever represented that is more committed to the rule of law in international relations than Japan. And so it is first entirely appropriate that it is the Japanese government that is sponsoring this seminar on international law. It's a reflection of the sincerity of Japan's commitment to a rules-based international order. And again, in that context, it's a particular honor for me to be here and to have been invited again to be a part of this. Well, I hope that will encourage you to speak out about international law during the course of this presentation. So let me go to the agenda that I have outlined for you, the decision to sue. The first question for any state is, who is the dispute with and what is it about? First, is there a valid legal claim that we can make against the state that we believe has violated its legal obligations toward us? And what is the injury suffered? But litigation is not the only response, of course. Is there a better way to resolve the dispute than litigating or arbitrating? Hopefully there is. Hopefully diplomatic engagement can lead to a solution. If direct negotiation fails or is not possible in the circumstances, there are different forms of mediation particularly through the United Nations or through regional organizations, or sometimes through the good offices of a third state. An example being China's role in improving relations between Saudi Arabia and Iran a year or so back. The Secretary General of the United Nations offers a good offices process for mediating disputes between states. Of course, direct negotiations are best, but for a variety of reasons, they don't always work. And litigation is adversarial. And so the decision has to take account of what will be the effects on our overall relations with our neighbor. There are economic relations, commercial relations, trade relations. There are maybe border issues and cross-border flows. There are a whole panoply of issues to take into account. How will our decision to sue our neighbor, how will it affect their behavior, not only in response to this particular suit, but on other issues that are important to us? Will they retaliate against us, or will they harden their attitudes on other issues? So all of these issues of a political and practical sense go into the process. Now, these are not issues in which somebody like myself can offer helpful advice. I can offer advice on, is there a valid legal claim? What are the prospects of prevailing if the state decides to go to court or arbitrate? I'm using the word litigate for both. What are the prospects for success, and what outcomes are likely to be achieved in terms of compliance by the other state with the international legal obligations that you feel they have violated? But again, there are the entire relationship between the two states has to be taken into account before a state decides to litigate against another. And special attention has to be given to other non-adversarial means of resolving disputes. So litigation and arbitration, I won't say it's a last resort, but it's near the bottom of the list before that decision is made. But as we have seen, international litigation and arbitration is becoming more prevalent rather than less prevalent. So we can see that there are more situations, increasingly more situations, in which states feel that they have no other alternative. I think the docket of the International Court of Justice is more crowded now than it has ever been. Just a comment here, and maybe it's a cause not to be so glum or grim about the present status of the international legal order. While certainly the threats to the order are real and major, at the same time, we see increasing resort to international law to resolve disputes between states. So this is going on at the same time. While the rules-based international legal order is under serious threat, at the same time we see a greater resort to rules-based dispute resolution mechanisms. that should be borne in mind as we look at this situation. Another aspect in deciding whether to sue is the cost. And I've mentioned some of the political and diplomatic costs involving the impact on the relationship with the state that you are planning to sue. There are also financial costs. Litigation is expensive. Arbitration can be even more expensive because the states involved have to pay the arbitrators. At least litigation in international courts like the ICJ and ITLOS, there are no administrative costs for the tribunal. Those costs are covered by the United Nations. But there are costs, and there are also costs in terms of time and administrative resources of the state. My strong advice is don't leave it entirely to the lawyers. This is the state's case, and the state must own the case. And of course, one hopes that you will be able to trust the lawyers that you've hired. That's why you've hired them, because they're people you think you can trust. But the state has to take ownership of its own case. And that means responsible officials, whether it's the Foreign Ministry or the Attorney General's office or the Office of the President or Prime Minister, or a combination of all of them. Or if it's a boundary case, it can often be the Armed Forces and the Ministry of Defense that have a stake and form part of the team. But the state itself has to take ownership of the case and make sure that it fully understands what the lawyers are doing, and it can give appropriate guidance. So all of these are factors that go into the decision whether to sue. One more is there jurisdiction? Can we take the other state to an international court or an arbitral tribunal? And as you know, the ICJ does not have universal jurisdiction, nor does ITLOS. States are sovereign, and they cannot be sued without their consent. States consent to sue in a variety of ways. One is voluntarily accepting the compulsory jurisdiction of the court under Article 36 of its statute. Some 70 some odd states have submitted declarations accepting the jurisdiction of the court, some with reservations, others without. States also consent to the jurisdiction of the court in either bilateral or multilateral conventions. The Genocide Convention, for example, that's one of many multilateral conventions that has a clause in it which provides that in the event of a dispute arising under the interpretation or application of this convention, a party can submit the case to the International Court of Justice. You find similar clauses in the Convention Against Torture and many other multilateral conventions. Sometimes they have jurisdictional prerequisites. The Convention on the Elimination of All Forms of Racial Discrimination, the Third Convention of 1965, provides that there must be recourse to the court must be preceded by an attempt to negotiate a resolution. The Torture Convention, or Anti-Torture Convention, provides that a state must propose arbitration to the other state, and the states must fail to agree on arbitration before recourse can be had to the ICJ. The United Nations Convention on the Law of the Sea also provides for compulsory jurisdiction for most disputes that would arise concerning the interpretation or application of the convention. The default is to arbitration under the rules set forth in Annex 7 of the convention. So, and then it is also always possible for two states to agree on an ad hoc basis to submit their dispute for resolution by the ICJ. A recent example is Equatorial Guinea and Gabon, which have a very long-standing dispute over their land boundaries and over sovereignty over disputed islands off the coast. And they reached an agreement years ago to submit the dispute to the ICJ, neither having accepted previously the compulsory jurisdiction of the court. And the ICJ very recently, earlier this year, issued its judgment in that case. So is there jurisdiction? And sometimes there is more than one forum in which jurisdiction lies. There might be jurisdiction in the ICJ, and there might also be, if both parties are, as most states are, parties to the Convention on the Law of the Sea, there might be jurisdiction under UNCLOS, under that convention. And so sometimes a decision has to be made at the outset. Do we want to take this case to the ICJ, or do we want to take it to either ITLOS or an arbitral tribunal established pursuant to that convention? And the considerations, of course, will vary depending upon the nature of the case, the precedents in the different courts, but those are factors that have to be decided in the beginning. Now, I will give you some examples from my own experience of decisions made by states on suing another state and where. Again, if any of you would like to educate us, the rest of us, on decisions made by your state to sue, I would invite you to do so. But I'll start the ball rolling. The very first case, international case that I did was Nicaragua against the United States. I was counsel for Nicaragua. And the circumstances there leading to the suit, I think, are informative, and they give an illustration of many of the points I was describing just a few moments ago. Just to set the background, as the years are passing and the audiences are getting younger, I am not. I'm not as certain that everyone remembers the circumstances that led to that case. But a new government came to power in Nicaragua in 1979, a revolutionary government that overthrew a military dictatorship that had been in power for 40 years and allied with the United States. And there was immediate suspicion and hostility from the North. The U.S. administration determined that the Sandinista government in Nicaragua was somehow a threat to its security. They considered Nicaragua to be close to Cuba and aligned with the Soviet Union. This was during the height of the Cold War. And they set about to bring down the Nicaraguan government. they began by organizing the armed forces of the dictatorship who had fled the country and set themselves up in neighboring countries. And so the United States, through the Central Intelligence Agency, organized these forces, trained them, armed them, and directed them to conduct military and paramilitary operations in Nicaragua with the aim of bringing down the government. I was consul to Nicaragua during this period, and the government was duly concerned that it was confronting a challenge to its existence by the most powerful nation on the planet at the time. And they made many overtures to the U.S. to engage in dialogue, to resolve the disputes diplomatically, to explain to the United States that they represented no threat to the U.S. or to any of their neighbors in Central America. And they even tried mediation through friendly governments that were friendly to the United States in Latin America and in Europe, some of the U.S.'s NATO allies. But the U.S. was committed. It was a very ideological approach, and they were committed to the overthrow of the government, and there was no possibility of negotiation, of a successful negotiation or other means. So Nicaragua at the time, faced with very few options, decided that its best course of action would be to sue the United States in the International Court of Justice for fundamental violations of international law, the use of force, violation of its sovereignty and territorial integrity. And the idea was to create public opposition in the United States to this policy by publicizing and bringing to widespread public attention that the United States was not only violating fundamental principles of international law, but its own commitment as inconsistent as that might have been to the rules-based international order. And so that was the reason that the case was filed, and it turned out to be a very successful effort by Nicaragua, and ultimately resulted in bringing the U.S. policy to an end and ending what had become a civil war in Nicaragua. I also helped Georgia make its decision to sue Russia in 2008. Georgia was in a very vulnerable position. Russia had invaded its northern provinces, which had strong separatist elements. The province of South Ossetia was populated by ethnic Georgians and also ethnic Ossetians who were Russian-speaking and sympathetic to Russia. But they had lived together in relative harmony. To be sure, there were some villages that were ethnic Georgian, some ethnic Ossetian, and some that were mixed. People lived together. When the Russians invaded, Georgia was faced, obviously, with a crisis. And the question was, what could they do? They tried diplomacy, but the Russians were not interested. There was some foul language used by the Russian president to describe the Georgian president, and who responded in kind, and the relationship was not very conducive to dialogue. And so Georgia was looking for what can we do to save our country. And the jurisdiction was difficult because Russia had not accepted the compulsory jurisdiction of the court, as the United States had done at the time of the Nicaraguan lawsuit. So, but it turned out that, so this was a case of aggression, it was a case of violation of sovereignty and territorial integrity, violation of the UN Charter, but there was no jurisdictional basis to sue Russia on those grounds. But Russia was a signatory to the Third Convention, the Convention on the Elimination of All Forms of Racial Discrimination, which I described a few moments ago. And Georgia was able to find a jurisdictional basis there. The question was, is this case about aggression, in which case there's no jurisdiction, or is it about racial and ethnic discrimination, in which case there would be? Well, in fact, when the Russians invaded, they engaged in ethnic cleansing, and they forced all the ethnic Georgians out of South Ossetia, principally in order to create an Ossetian-only province, which would then declare itself independent and align itself with Russia. So there was plainly ethnic cleansing, and that gave Georgia a basis to bring the lawsuit under the Third Convention. I represented the Philippines against China in the South China Sea arbitration. That was also that was also a situation that posed jurisdictional challenges. Here again, for those of you who may not be entirely familiar, China had asserted claims really to the entire South China Sea based on what they claimed were historical rights. Whereas under the UN Convention on the Law of the Sea, states, as you know, are entitled to a 200-mile continental shelf and a 200-mile exclusive economic zone. China's claims extended more than 600 miles from its coast and came within 50 nautical miles of the Philippines coast. Of course, these claims to the South China Sea also adversely affected Vietnam and Indonesia, and to a certain extent, Malaysia. The Philippines had tried negotiating with China. That, of course, was the preferred option. The Chinese claims also extended to sovereignty over the islands, all of the islands in the South China Sea, including particularly the Spratly Islands, where the Philippines and Vietnam, and to a certain extent Malaysia, had claims to certain of those islands. And the Chinese proposition to the Philippines was, okay, well, first you accept our sovereignty over the South China Sea and all the islands, and then we'll negotiate with you. Well, of course, then there was very little to negotiate. So the Philippines explored options for compulsory dispute resolution. Of course, both states were parties to the Law of the Sea Convention. What made it challenging for the Philippines was that under Article 298 of the Law of the Sea Convention, China had opted out of compulsory arbitration of the delimitation of maritime boundaries. So the Philippines had to find a way to bring a case that could accomplish its objectives without seeking to establish maritime boundaries. And basically the solution that was found was that under the Law of the Sea Conventions, as I've said, there are entitlements to a 200-mile continental shelf and a 200-mile exclusive economic zone. And what the Philippines did was frame its case around entitlements rather than delimitation. Delimitation is only required when the entitlements of two states overlap, either because they're adjacent to one another or because they're opposite, but within 400 miles of one another. So here, the Philippines and China, except for a very small area to the northwest of the Philippines, they are located more than 400 miles from one another. And therefore, there could be no overlapping entitlements. And the issue that the Philippines litigated was, what are the Philippines' entitlements and what are China's entitlements? And that way, they avoided the issue of delimitation. And the tribunal ruled unanimously that China's entitlements did not extend beyond 200 miles, and that therefore its claims in the southern part of the South China Sea were invalid. I could go on telling war stories like this, but maybe I've exhausted your patience for that. But every case has its own history, and these are what I'm trying to illustrate here is the kinds of decisions that the factors that go into the decisions to sue or pursue other means of dispute settlement. So I don't know if anybody wants to make a comment about any of the disputes or litigations or arbitrations that your state was involved in. This will be a good time if anybody wants to do that. But if not, we'll go on to the next point. The composition of the legal team. Now, every legal team in international litigation or arbitration has two components, the national component and the external or international component. So in terms of the national component, it's important to decide at the outset which ministry or which agency of government is the lead, is going to take the lead on this. I've been in situations where there were conflicts over how to manage the case between different parts of the same government. And that is a formula for losing. It makes it almost impossible to have a coherent management of the case. So somebody has to be in charge. That doesn't mean that they take decisions without consulting other ministries or other stakeholders. In fact, it's very important that all of the most important stakeholders be represented on the national team. That all of the agencies, whether it's Attorney General, I mentioned some before, that have a stake, or that feel they have a stake, have a representative on the team, so that the views of that agency can be taken into account in making strategic decisions. And in fact, some states have included members of the political opposition on the teams. And this can be very wise. It depends, of course, on the political relations within the state. But I'll give you an example. I represent Guyana in its case against Venezuela in the International Court of Justice. It's over disputed territory. I won't go into the details unless anybody asks me later. But the government believed that it's very important that this be a national effort and that the opposition be represented on the national component of the legal team so that they had a say, they had a voice in the decisions that were being made, it reflected a true national commitment rather than a political commitment from one party, but it also provided some insulation for the government, some protection for the government against criticism by the opposition party that it was mismanaging the case or that it was taking actions that were irresponsible or that would lead to defeat. And so it has worked very well for Guyana in those circumstances. Contrary to that, I represented Mauritius for almost 15 years in its effort to recover or regain sovereignty over the Chagos Archipelago. This went through a variety of fora, starting with arbitration under the Law of the Sea Convention, and not culminating, but the high point was the advisory opinion issued by the International Court of Justice in 2019, which ruled that the British had illegally severed the Chagos Archipelago from Mauritius when it granted Mauritius independence, and that the legal consequences were that the continuing or ongoing British administration and occupation of the archipelago was an internationally wrongful act, and that the British were under a duty to withdraw and recognize Mauritian sovereignty as rapidly as possible. This led to a General Assembly resolution implementing the advisory opinion, and ultimately to negotiations between Mauritius and Britain. Now, the negotiating team, of course, it included lawyers like myself and Philippe Sands, and representatives of the government, who led the team and did an exceptional job, a brilliant job, ultimately resulting in an agreement. But they did not include or even consult during this process, during this negotiating process, with the political opposition. And there were strained relations between the two parties and their leaders. I know somebody is from Mauritius here. Okay, so I see the smile. So you know perfectly well what I'm talking about. Well, what happened was that we reached an agreement with the British in October of last year, early October, a complete agreement on the treaty. And the government, the then government, was really, really pleased, happy with the agreement, as they should have been. But then new elections were called, and the Prime Minister and his party were voted out of office, and his arch rival was elected. And the first reaction they had to the treaty was, oh, this is a complete fraud. We don't trust it. We don't trust the previous government. This is a sellout to the British. And this was without having read the treaty yet. The better sense prevailed, and over the course of the next month or two, the government recognized that this was a historic opportunity to make an agreement, and they re-engaged with the British. But they had painted themselves into a corner by declaring politically, I no longer represent Mauritius, so I'm free to speak about this. But they realized, well, we have just declared this whole treaty fraudulent, but it turns out we really need to sign it. So they spent a couple of months trying to negotiate changes. And after 2 years of strenuous negotiations, the British had had enough. They made enough concessions. So in the end, they made some cosmetic changes, nothing really of substance. The British were prepared to do that. But by the time they had reached this agreement, in January. Several months had gone by, and the British were now reluctant to go ahead when a new administration was coming into power in the United States in 5 days. And an administration that possibly would not be as welcoming of Mauritian sovereignty as the outgoing U.S. administration was. So it took several months while this hung in the balance, while the British waited for their American allies to finally give their assent. And fortunately, that came, and the treaty is now undergoing ratification by the Parliament in the UK and eventually by the Parliament in Mauritius. You can correct me if I get any of this wrong, or, and please do, because I don't want to get it wrong. So I think the treaty will ultimately be ratified. But it is, if you contrast the Guyana situation and the Mauritius situation, there's a lesson in the value of, if political relations allow, of including on the national part of your legal team representatives of the opposition. Of course, every state is different, and it may be difficult to do that, as it was in Mauritius. I think it's also very important on the national team side to include lawyers from the government to give, who will be groomed, if you will, to become international legal experts for the government. This is an opportunity to learn and to get firsthand experience. There is no better way to get litigation experience than to participate in a litigation, so that when you have a case, it's extremely important to designate lawyers, whether it's from the Foreign Ministry or the Attorney General's office, however your government is structured. But this is an opportunity to develop in-house or homegrown talent that you can use not only in future cases, but in advising on all sorts of questions of international law based on the litigation experience. Those are my comments on the national component. Now, on the international component, I think it's very important to have a lawyer or lawyers who have substantial litigation experience, particularly before the forum where your case is going to be heard, whether it's ICJ or ITLOS or elsewhere. That experience in terms of knowing the surroundings, knowing the judges, knowing how to present arguments that will be most persuasive or most receptive to the judges, knowing how the court functions and how the judges or arbitrators are likely to think. That is, as well as knowing the procedures of the court, which can be very formal. That kind of experience is invaluable. You also want someone, or more than one, who are experts on the law that will be applied in the case. If this is about ethnic cleansing, you will want not only a lawyer who has valuable experience practicing before this particular court, but lawyers who understand the CERD Convention, who understand the Geneva Conventions, who understand international human rights and international humanitarian law, and can speak authoritatively about those subjects to the court. And you would want lawyers who can can work together well. It's very important that the team have what I call good chemistry. You're under great stress, whether you're part of the national component or the international component. There's a lot riding on it. I mean, the case may be existential, as Guyana's case against Venezuela. Venezuela claims 2/3 of Guyana's territory. This case is existential for Guyana. Nicaragua versus the United States was existential for the United States. But it doesn't have to be existential. It could still be extremely important in terms of affecting vital national interests. So there is a high priority on having people who, under this kind of stress, and litigation is always stressful, particularly when you get to oral hearings, because you have very little time to prepare your responsive arguments, particularly in the second round. So people have to be able to subordinate their own egos and their own certainty that they're right about the way the case should be argued, and listen. Be able to listen, but listen with an open mind to different ideas by their co-counsel and by their clients, by the national team as well as the local team. I have been on teams that have, fortunately, most teams I've been on have been highly functional, but I have been on dysfunctional teams where, I mean, let's face it, we all have egos, and international lawyers do not generally have small egos. So we all like to think that our idea is the right one. But there are some of us who, as confident as we may be in our own analyses and our own opinions, understand that this is hard stuff, and nobody is right all the time. And if we can have everybody contributing, everybody on the team contributing their best ideas, and we can, as adults, debate them. And not with the idea of, I want my idea to prevail, but I want the best idea to prevail. And the best way to get there is to have a clash of ideas without investing egos in who's right and who isn't, but everybody committed to producing the best idea for the client and the case. Now, that seems pretty obvious, that this is the best solution. But to get there, you have to be careful that you compose your team of people whose record shows that that's the approach they take. I'm not going to mention any names, but I've been on teams. Of course, before the ICJ, which has two official languages, English and French, you're going to have, it's important to have Francophone and Anglophone advocates. You don't want the French-speaking judges on the court to feel that they're second class because you don't want to address them in French. So it's very important to respect the Francophone judges and the French language. And it's also very useful to have French advocates because there's often a different approach, a different analytical approach than we common lawyers from Britain, the United States, or other common law countries have. And again, you have a diversity of approaches and you discuss them and you ultimately come out with what you think is the best approach. You have the strongest case that way. But I've been on teams with British and French lawyers, and you would think the 100 Years' War was still going on. I remember I joined one team late, and there was a dinner party at the ambassador's house, who was the agent. And of course, I had known these lawyers from previous encounters. And one of them came up to me at the party and said, "Oh, Paul, I'm so glad you're on the case because I need your support because so-and-so is impossible." And about 15 minutes later, so-and-so, the other lawyer, came up to me and said, "I am so glad to see you here because you know that one, and you just can't work with him. You realize then that there are problems on this team, that some people aren't listening to each other because they're in competition with each other. So chemistry is very important. Now, one other thing, I've talked about English speaking, French speaking. It has become increasingly important, and this is a very good thing, to have a diverse team in terms of gender, race, and nationality. The judges want this, and it's the right thing to do. Opportunities have to be provided for more opportunities have to be provided for women and for people who are not white, male, and from the West. I'm guilty on all those three counts. And I think that it sort of reflects the way the court and the bar used to be. I mean, ages ago, the court was composed basically of white men. That is no longer the case. I mean, there are prominent women judges, African judges, Asian judges. We know from previous speakers that the president of the court is Japanese. He's doing an outstanding job. But the bar has been slower to modernize. And I think one of the reasons is that historically, the bar before the ICJ, and there are exceptions, but historically, most of the advocacy has been done by white men from Western countries, Western Europe, North America. And I think that kind of prejudice which is built into the system lasts even when the composition of the court reflects humanity in its entirety, because states are prone to select the people with the greatest experience. So if the ones with the greatest experience are white males from the West, the pattern just keeps being repeated. And that has to change. And I think it's up to those of us who are frequently appointed to speak with our clients and explain how much better they will be received by the court if their legal team reflects the diversity of their own societies and of the world. And this is not a way of in any way diminishing the skill level or the competence. Quite the reverse. When you see hearings in advisory proceedings, most recently we've had on climate change, on the denial of humanitarian aid to Gaza, and last year the legality or illegality of the prolonged Israeli occupation, annexation, and settlement of Palestinian territories, where dozens of states have participated. You can see, because there are so many oral advocates, because so many participants, the room is filled with advocates who are other than the usual suspects. And you can really see that when given an opportunity, younger lawyers more represent the diversity of the world, are outstanding, and they need to be given a chance. And I've talked to my colleagues about this. This means that maybe some of us, including myself, have to be willing to step aside from time to time to open the doors, to give room to younger, talented people from around the world. But at the very least, we need to encourage our clients, after we're appointed, to compose the team, taking the need and the advantage of diversity and inclusion into these. By the way, these have become forbidden words in the United States, but I'm in Japan, so I can use them. But we need to be conscious of diversity, inclusion, and equality in the composition of teams. And it's in your interest to do that. I think I've covered the issue of the composition of the legal team. And let me ask, what would be the appropriate time to break for lunch? This was supposed to go from 11 to 12:40, so.
That's correct, but
Okay.
we can be flexible
All right.
depending on how you want to.
Well, if you have the endurance, I can go on for another half hour before the lunch break. Is that okay? And be honest with me. If you need a break before that, let me know. Okay. Well, we've decided to sue. We've decided which court, and of course, which opponent. And we've put together our legal team. So there's one more thing we do before we initiate the proceedings, and that is we put our case together. So we need to understand fully the law that will apply to our case. We need to do thorough legal research, and we need to understand from the precedents what the attitudes of various judges or arbitrators might be, and we need to develop what will our legal arguments be. But equally important is our factual research. What are the facts? I think experienced litigators will tell you that most cases are won or lost on the facts, which is not to minimize the importance of the applicable law. It is the law that will be applied to these facts that will determine the outcome. Many scholars who become practitioners will focus primarily on the law because that's what they're accustomed to doing as scholars. And that's okay. But what is a problem is if equal attention isn't given to the facts, to the evidence. Because as I've said, I think most practitioners will tell you that more cases will be decided depending on the facts. And it is, what do we mean when we say the facts? Well, when we present our case, I see it this way. We're telling a story. Every case that you present, it's a story. It's a narrative. And, of course, it's not, this is not a modernistic story where there are no rules or limits. The story is told within the confines of the applicable legal rules. And within those rules, we want to tell a story that is as compelling as possible. Our story, why we're right, and we deserve what we're asking for. So, what makes a good story? Well, I think we could all answer this. A good story is one that holds your interest. It has to be interesting, like a well-written novel. Preferably, the story has a very nasty or dishonorable villain and an innocent, righteous victim, with a grave wrong done to the victim, which offends our sense of justice and inspires in us a need to make things right. Now, this is fairly simplistic, but this is sort of the guiding overview. We want to tell a story. It has to be interesting because we want the judges to be interested in it, to follow it. We don't want them to be bored or lose interest. And we're telling a story that has to lead, again, bearing in mind the legal rules that are applicable, lead to a result that we want. What do we want? We want the court to rule in our favor, whatever it is we're asking for. So we have to show that justice demands what we're seeking. And that means we are the victim and the other state is a wrongdoer. Now, these elements are borne in mind as you develop your narrative. I mean, this is not Little Red Riding Hood or a Tale by the Brothers Grimm. It's more sophisticated than that. But in its essence, this is what we're trying to accomplish. Now, another difference between this and the fairy tales I just cited is this is not a novel or a tale. It has to be scrupulously factual. So the story that we tell has to be accurate, it has to be true, and it has to be based on actual evidence, usually in the form of documents. It has to, what we say has to be provable. It's one thing, we know this is true, this is what happened. Yes, but can we prove it? What proof is there? And so we tell our story based on provable facts. So it is an evidence-based narrative where one element leads logically to the next, which connects to the next, and it leads to the conclusion that we're right and we're entitled to the remedies that we seek. So how do we begin to develop our story? We begin with the basic facts that are initially available to us. And so we conceive our story in general terms, our narrative. This is what we think happened. These are facts that we know, but we don't have all the facts at the very beginning. There are gaps. And so if we want to tell a story, every element of which is provable, we have to recognize, identify where the gaps are, and develop a procedure for filling in those gaps. Where do we find the evidence that will support what we think is the next step in the narrative? So, as I said, the facts will not always line up in an unbroken chain. So we're going to have to investigate and find those missing facts. And what we do is we look first for documents, because compelling proof will usually consist of contemporaneous documents, not documents that are produced after the litigation is commenced because, or some period of time after the events at issue occurred, because they may not be accurate, they may not be reliable, they may not be trustworthy. But contemporaneous documents that reflect actions that were taken, messages that were given, statements that were made, communications back and forth at the time or prior to the time the dispute arose. So the first place we look is in the files of the client state. And the records of the relevant events may be in various locations. They may be in the Ministry of Foreign Affairs, they may be in the Ministry of Defense, they may be in the Ministry of Trade. So the national component of the team undertakes to canvass all of the agencies in the government that might have relevant documents to collect them. So we search the files and archives of all the relevant government agencies that might have something useful. Now, there's one risk here, and I've seen this happen in a number of cases. Of course, you can't have the lawyers, particularly the international lawyers, going through all of these government files. In some cases, there may be sensitive material unrelated to the case that you want to keep confidential. But also, it's a very, very large undertaking. Is this on? Is this working? Oh, there it is. Okay. So you can hear me now? Now I hear my echo, but is this okay? So and also it's very expensive to pay the lawyers to go through all these files. So you're normally going to have people from your government and sometimes junior people going through all these files, depending upon how extensive they are. Now, one caveat here is that this actually happened to me in a case, and I know it's happened in other cases too, that in their eagerness to be helpful, sometimes the people who are assigned to look for the documents find a document that is relevant but not helpful, say harmful. It contradicts the story we want to tell. And so the individual who sees this is going to make a decision. Should I show this to the lawyers, to the legal team, because it's part of what they've asked for? Or maybe it's better they don't know about it because it harms our case. Now that can be a fatal mistake. What I always advise my clients is anything that is relevant, please produce it. And if it's harmful, if it contradicts the story that we plan to tell, that's even more reason that we need to see it. Because one, it may be we need to change our story to account for the fact that this part of it is not supported by our documentary evidence. There's plenty of time to do that. And then there's the other problem, is that a copy of that document may be available to the other side. And what happens is the lawyers don't know that this document exists until we get to the hearings and it's presented by the other side and we don't have time to develop a response to it. So I always say, however bad this may be, there's a way to respond to it or minimize its impact if we know about it in time. And as I said, it may very well be. We're developing our story. The story, we haven't presented our written pleadings yet. We haven't even presented our application yet. There is plenty of time to to change the story so that it still reaches the right conclusion, but it's based on facts that are provable. I like to analogize this to a police detective. Experienced police detective investigating the commission of the crime, develops a theory of the case based on the evidence that is available. And that evidence leads our detective to conclude that Mr. X committed the crime. But the evidence isn't yet conclusive, and the detective is a serious person who wants to get it right and doesn't want to accuse the wrong person, so continues the investigation. And as the investigation further develops, new facts come to light, which suggest, well, maybe there's another suspect. Or maybe the motive was not the one we thought, but there's a different motive that caused Mr. X to commit the crime. So what do? You now have new facts. You had a theory of the case because you start with a theory of the case and then you try to fill in the details that you don't have. So you have all of the evidence leading to a solid conclusion. But when you find evidence that suggests, well, maybe my theory of the case was off, what do? We develop a new theory of the case. So we have to be flexible. We go where the evidence takes us. And we make our factual and legal arguments based on the evidence that exists. And we have to be prepared to jettison our initial theory of the case, our initial narrative, if when we go to fill in the gaps, we find this is not what happened. It happened differently. So you always want to base your narrative on the facts, and as you find more facts, you fill in those gaps, and sometimes that requires you to alter the narrative. Of course, you're not neutral. The conclusion has to be the same, that you're right, the other side is wrong, and you deserve justice. But how you get there has to be supported by provable evidence. Now, I've said that we rely to a great extent on contemporaneous documentary proof. But there are other forms of proof that are equally important and sometimes more important. Statements by the other side. What we call admissions or declarations against interest. When Nicaragua sued the United States, we relied to a great extent on statements by senior U.S. officials who had publicly announced that they were supporting these paramilitary forces. If you have a good memory, they were called the Contras. But this was the paramilitary force that the United States had organized to overthrow the government of Nicaragua. U.S. officials, for political reasons, were bragging about organizing this force, supporting it, providing arms. In fact, there was legislation in the U.S. Congress to provide funding for arms for these people. So, of course, Nicaragua had evidence of what was going on in its own country. But some of the most powerful evidence we had of what the U.S. was doing was publicly available in the United States, public statements by senior officials, speeches in the Congress, and actual U.S. government legislation. Another example more recently is in the advisory proceedings before the ICJ last year. And as you know, advisory proceedings are commenced by a resolution of the UN General Assembly asking the court to give its legal opinion on certain matters that are of interest to the General Assembly and within its mandate. And so the General Assembly asked the court to issue an advisory opinion on what was called the legality of the prolonged occupation, settlement, and annexation by Israel of the occupied Palestinian territory. And I had the honor of speaking for Palestine at those hearings. And some of the most powerful evidence that we used were statements, public statements made by senior Israeli officials, and maps published by the government of Israel. I'll come to the statements in a moment, but they published maps of Israel, official government maps, which showed the entire area from the Jordan River to the Mediterranean Sea as Israel. There was no Palestine. There was no West Bank. There was no Gaza. There was no East Jerusalem. It's all Israel. This is an official Israeli government map. There were, and then there were statements, and we had so many of them that we had to be very selective. But we relied principally on statements made over the years by Prime Minister Netanyahu that talked about what we know as the West Bank by their biblical names, which is how they're known in Israel today, Judea and Samaria, as integral and permanent parts of the state of Israel, as Jerusalem being united for all time and being permanently within the sovereignty of Israel. So they had many, many statements indicating that this was not really an occupation, but it was an annexation, an ongoing and progressing annexation of Palestinian territory. Now, under international law, as you know, military occupation at the end, during or at the end of a war may be permissible, but it comes under certain rules. It must not be permanent. It must be temporary. And the occupied territory must be governed in the interests of the indigenous population. And furthermore, the occupying power is forbidden from transferring its own citizens into the occupied territory. And of course, the evidence showed that Israel had violated these really peremptory norms of international law in all of these senses. And the court ultimately concluded, and I think it was influenced to a great degree by the statements of the Israeli officials admitting what they were doing and why, and that the intent was permanent annexation, which would constitute an acquisition of territory by force in violation of the UN Charter. So when we look for evidence, we look within our own files, but we also scrutinize statements and actions by the other side where they might have admitted to committing the acts that we consider constitute violations of their legal obligations. So contemporaneous documents, statements by officials of the other side. I'm gonna give you a break for lunch in a minute, but let me just, another vital source of evidence can be authoritative reports by reliable and independent agencies, particularly United Nations agencies. The ICJ in particular relies heavily on authoritative reports by reliable UN agencies. In Gambia and Myanmar, the case in which I represent Gambia, it's a case under the Genocide Convention based on Myanmar's, what we consider, genocidal activities against the Rohingya Muslim population of Myanmar, particularly in the years 2017, 2018, but ongoing. And of course, we haven't had our final hearing yet. That'll be in January. But at the provisional measures stage, the court issued provisional measures unanimously based in large part on fact-finding missions produced under the aegis of the United Nations, extensive fact-finding missions of Myanmar's activities against the Rohingya Muslim population, which were, according to the United Nations reports, were evidence of genocide. The court did not make final rulings on the merits, but it based its provisional measures on the contents of those reports. I'm going to stop here. I think this is a good time to give you a lunch break, and me. So we'll break here, and our host will tell you when you're expected back, and I'll see you after lunch, and I wish you a pleasant lunch.